Good day, Crime Talk aficionados. Witnesses in the Bryan Kohberger matter speak out in a docuseries ahead of his trial. We have the closing arguments in the Karen Reed case, a quick update on the Travis Dacker matter, more freakiness in the Sean Combs trial, and guess who showed up to watch? At least this guy felt bad after using a machete to attack a woman. We have this day in legal history, our quote of the day, and, well, our dumb criminal of the day is a quartet of dumb criminals. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications so you get notice of when we go live or put up new content. And yes, you can check us out on any of your favorite podcasting apps if you like to listen that way as well. So before we get to the docket, let me remind you, go to crimetalksearch.com and sign up for that background subscription service today. When you do, you'll be able to do as many background searches on anyone that you desire here in the United States while you have that subscription. And remember, you can cancel at any time. So whether you want to do one search or 100 searches or 1,000 searches or one a month, it's completely up to you. But you type in a name, you're asked a couple of questions, a report is literally prepared while you wait. That report is emailed to you, and it's going to have all types of information that you just can't get on your own. It's going to have phone numbers, email addresses, social media presence. It's going to have criminal histories. It's going to search thousands of public databases across the United States, and you're going to find out if there's a criminal history. Maybe if somebody's on one of those sex offender registries. Yes, things that people may not want to tell you about when they're getting to know you. So if you have somebody coming into your life, or maybe you're not sure, you're getting those warm, fuzzy feelings from somebody, check them out. Maybe there's something in their past. CrimeTalkSearch.com. You're going to be happy that you did it. All right, ladies and gentlemen, it is Friday, June 13th. Let's go ahead and open the record. And first matter on the docket, Bryan Kohberger. That's right. Students speak out in the docuseries ahead of the Bryan Kohberger trial. So for those who don't know, on November 13th, 2022, 4 University of Idaho students, Kayla Gonzalez, Madison Bogan, Xana Kernodle, and Ethan Chapin were fatally stabbed at their off-campus residence at 1122 King Road there in Moscow, Idaho. Now, the gruesome discovery was made by friends Emily Allant and Hunter Johnson, who were called to the scene by surviving roommates Bethany Funk and Dylan Mortensen. Now, nearly 3 years later, Allant and Johnson are sharing their account for the first time in a Prime Video 4-part docuseries that is titled One Night in Idaho. Now, obviously, the morning of the discovery, according to court documents, details Mortensen's encountering a masked intruder in the early morning hours on November 13th of 2022 around 4 a.m. She describes seeing a man wearing all black, a mask moving towards the back side of the house, and after hearing disturbing noises and failing to reach her roommates, Mortensen exchanged frantic texts and calls with Funk, the only roommate who responded. Now, messages included Mortensen's concern about an intruder and her growing panic, with one text stating, quote, "I'm freaking out right now," end quote, and describing the intruder's mask. The 2 roommates eventually retreated to Funk's first-floor room, remaining there until morning. By 11:50 a.m. with no response, Gonzalez, Mogan, Kernodle, and Chapin, Mortensen contacted Allant, asking her to check out the house. Allant arrived with her boyfriend Johnson and met Mortensen and Funk on the ground floor. As the group ascended to the second floor, Johnson retrieved a kitchen knife from the kitchen for protection. There, they discovered Kernodle's body, prompting an immediate call to 911 from Funk's phone. In the call, Allant reported to the dispatcher that they had seen an unknown man in the house the previous night. Arriving officers confirmed all 4 victims were deceased. Now, the One Night in Idaho trailer highlights Allant and Johnson's emotional recounting of the discovery and their suspicion that the victims may have been stalked for months prior to the murders. Now, Allant questions why the killer targeted their close-knit group of friends, stating, quote, "There's a big realization that we had been stalked for so many months and had no clue," end quote. The series also explores the intense online scrutiny faced by survivors and friends, including Alon and Johnson, who endured accusations and death threats. Johnson notes, "People were thinking we were murderers," while other friends described being falsely implicated online with photos of his home circulating online. Now, the docuseries features interviews with victims, family members, and friends, including Ethan Chapin's triplet siblings, Hunter and Maisie Chapin, who also attended the University of Idaho. Hunter Chapin reflects on the fear that gripped the community while the killer remained at large, saying, "There's this person out there who has just murdered our brother, and he's still out there somewhere." Additional interview includes Chapin's parents, Stacy and Jim, and Mogan's parents, Karen and Scott Laramie. Now, on December 30th of 2022, police arrested Bryan Kohberger, the PhD criminology student there at Washington State University, at his parents' home in Albright, Pennsylvania. Now, Kohberger was linked to the crime through DNA evidence found on a K-bar knife sheath near Mogan's body. Cell phone records indicate the presence near the crime scene multiple times before the murders, and surveillance footage of a vehicle matching his car fleeing the area. Now, Kohberger's trial is scheduled to begin on August 11th of 2025 there in Ada County, Idaho, with the jury selection expected to begin late July or early August. Now, if convicted, he could face the death penalty. However, a June 18th hearing is set, which could alter that timeline. Kohberger's defense team has requested a postponement, citing a recent Dateline episode that aired back in May that revealed new details, including Kohberger's alleged phone records, online searches, and previously unseen surveillance footage. The defense argues that this media coverage and the need for further investigation in regards to Kohberger's background for a potential penalty phase warrants this delay. Now, the prosecutors has opposed the request, asserting that the defense has had ample time to prepare since Kohberger's arrest back in December of 2022, and the prosecution has criticized the defense for pursuing every little rabbit hole and urged the court to proceed, stating it is time to try this case. Now, Judge Hippler will consider the delay arguments and the separate closed-door discussion on whether the defense can present an alternate suspect to the jurors. The outcome of these hearings will determine whether the trial proceeds as planned. Now, obviously, these murders have sent shockwaves through Moscow, Idaho, a small college town unaccustomed to such violence, and the home there at 1122 King Road became a symbol of the tragedy, and the prolonged absence of an arrest fueled fear and speculation. Now, the One Night in Idaho docuseries aims to provide a comprehensive look at the case from the harrowing discovery to the ongoing legal proceedings, while giving a voice to those most affected by the loss of everybody, the Gonzalez, Mogan, Kernodle, and Chapin family. We'll see if this is going to be another argument for the defense to try to ask for the continuance. It's also interesting that the family members are speaking out since they were subject to the gag order. So see how that's going to play in there. I guess, what is the judge going to do? Hold the family in contempt? Going to send them to jail? I doubt it. They can't even find who leaked the material to the press for the Dateline series, so I can't imagine they're going to do anything as it relates to the family as well. Obviously, the prosecutors, I'm sure, did not want anyone to be speaking to the press because guess what? The defense can try to get those recordings just like they did in the Karen Reed case, and it's can be a prior consistent or inconsistent statement, which could come back to bite potentially the prosecution's witness in their butt. All right, next on the docket, let's talk about Karen Reed. What is it, day 33, I believe. The jury finally got closing arguments. They got the instructions read to them, and they are now deliberating. It's about 3:38 right now. Still no verdict. I wouldn't expect them to reach a verdict that quickly. After 32 days of testimony, hey, you never know what a jury's going to do. They've had a lot of time to think about it. They can go back there. Hey, if everybody agrees, whether it's guilty, not guilty, they can do what they desire. The jury can take as much or as little time as they need to thoroughly examine the case and reach their decision. And whatever decision the jury comes back with, well, we will respect it. Because the jury makes the decision they have based upon the evidence there. So let's talk about the argument. All right. Let's talk about the arguments that were made in closing statements. Obviously, now normally, every jurisdiction I've ever practiced, the prosecution goes first, defense goes, and then the prosecution gets a rebuttal because they always get the last word because the burden is theirs. Here in Boston, the defense goes and then the prosecution goes. Either way, the prosecution gets the last word. So the morning started out with an extended sidebar. Apparently, Miss Reed was seen smiling multiple times at her father in the courtroom, and defense attorney David Yannetti pats Reed's shoulder, and she nods affirmatively towards her father. Now, the Judge Cannoni, and defense attorney Alan Jackson and Robert Alessi were also seen quite smiling at the sidebar. And Reed briefly leaves to work on her laptop with an X-ray image visible on her tech person's screen, suggesting, well, they're going to talk about that. Anyway, the defense and prosecution teams return to their desks, and the judge calls a quick recess. Sue O'Connell describes the Reed team as jubilant, though the reason remains undisclosed. Now, closing arguments were originally expected to start at 9 o'clock this morning, but they didn't start until almost 10. When the jury entered, the judge apologized again for the delays, emphasizing the need for accuracy. She instructs the jurors that closing arguments are not evidence and directs them to put away notebooks and underscores their role as the fact finder. The judge explains the Commonwealth's burden to prove guilt beyond a reasonable doubt, a constitutional standard, and each side is allotted 75 minutes for their closing argument, with the defense presenting their argument first. Alan Jackson did the argument. Open's repeatedly assertion was that there was no collision. He accuses the police of burying the truth, alleging that the investigation was corrupted from the start due to favoritism towards Brian Albert, a Boston police officer, and Jackson stresses that the jurors must be morally certain of the Commonwealth's case for a guilty verdict, a threshold he claims that has been unmet. Jackson then shows video from the Canton bar depicting Brian Higgins appearing fixated on John O'Keefe and gesturing as if to confront him. He criticized the lead investigator, Michael Proctor, for ignoring this evidence and failing to investigate potential events inside Albert's house, basement, or even the garage, raising questions about what was possibly overlooked. The defense attorney, Mr. Jackson, then argues the Commonwealth cannot prove O'Keefe was struck by a vehicle, citing the absence of bruises on O'Keefe's body and the flawed investigation led by Mr. Proctor. He questions why Albert, a trained first responder, did not assist in the chaotic scene and why Proctor never entered 34 Fairview Road, suggesting a cover-up. Jackson claims O'Keefe's arm was pristine, except for dog bites and scratches supported by X-ray evidence. He criticized the Commonwealth expert for finding no impact evidence and spending nearly $400,000 on misleading visual aids, like painting a model's arm blue, which he said provided absolutely no clarity whatsoever. Jackson presents evidence that O'Keefe's phone temperature remained steady, dropping only 20 degrees over an hour and never below 50 degrees, indicating it was not in the snow, but in a warmer location, such as the basement or the garage. He cites to Dr. Elizabeth LaPosada's testimony that O'Keefe showed no hypothermia signs supporting this claim. Jackson highlights Proctor's derogatory texts about Reed, noting his firing from the Massachusetts State Police for bias. He argues Proctor's handling of all key evidence, shirts, shards, and more, undermining the investigation's credibility, questioning why the Commonwealth avoided calling him as a witness. Jackson urges jurors to distrust Proctor, who handled all critical evidence, and notes the absence of biological evidence or DNA linking Reed to the crime. He claims the glass on Reed's bumper didn't match the crime scene glass, suggesting it was planted by Proctor, who didn't want the truth. Jackson asserts that Reed was not intoxicated, drove safely under the speed limit, and showed no signs of slurring or stumbling, corroborated by witnesses who testified. He criticizes the failure to search 34 Fairview for struggle signs, alleging favoritism towards Albert, preventing a thorough investigation, calling it pure favoritism, not justice. Jackson describes Reed's scene's statements, "Could I have hit him? Did I hit him?" as confusion and grief, not a confession. He questions Jennifer McCabe's behavior, suggesting she knew others were safe and raises suspicion about Brian Higgins' motives, ignored completely by investigators. Jackson points to Higgins' 1:30 a.m. visit to the Canton Police Department and flirtatious texts as evidence of motives overlooked by investigators. He notes that Higgins had access to Reed's SUV and taillight, raising doubts of evidence tampering, which he argues constitutes reasonable doubt. Jackson presents ring video showing Reed's SUV contacting O'Keefe's vehicle in a driveway, explaining the taillight crack. He alleges 42 minutes of Sallyport footage from the Canton Police Department is missing, suggesting police corruption and evidence manipulation. Jackson accuses the prosecution of misleading jurors about holes in O'Keefe's sweatshirt created by the crime lab, not the incident, and he calls the dangerous and a sign of desperation, as it falsely implied a collision, which he insists did not occur. Now, Jackson concludes that the Commonwealth's case is riddled with holes constituting reasonable doubt. He urges jurors to acquit Reed, arguing that convicting her would reward Proctor's misconduct and ignore science, physics, and the data. Jackson emphasizes there was no collision and calls for a not guilty verdict to uphold justice, stating, "Find Karen Reed not guilty, not guilty, not guilty." Well, then the prosecution took over. Mr. Brennan. He opens with his closing statement, arguing and portraying Mr. O'Keefe as a compassionate man who took in his niece and nephew and would help anyone. And he asserts that on January 29th of 2022, O'Keefe needed help after being struck by Reed's 6,000-pound SUV outside of 34 Fairview Road. And Brennan claims Reed, intoxicated with blood alcohol levels 2 to 3 times the legal limit, made a deliberate choice to hit O'Keefe and drive away without calling 911, running to his aid or seeking help of any kind, prioritizing herself over his life. Now, Brennan refutes defense claims of discord between O'Keefe and Brian Higgins, showing video of their friendly bar interaction with a celebratory mood. He described Reed and O'Keefe's relationship as toxic, deteriorating after a discordant Aruba trip and palpable discontent upon return. Brennan notes Reed's text to Higgins suggests the relationship was nearly over, and her excessive drinking that night, far beyond the legal limit, fueled tensions leading to the fatal incident. Brennan then plays a video of Reed's televised interview where she discusses weak drinks at the Canton bar, suggesting she underestimated her intoxication. He notes O'Keefe held a glass when leaving the Waterfall Bar and Grill, indicating continued drinking. Brennan claims alcohol escalated tensions en route to 34 Fairview, supported by data showing Reed and O'Keefe argue at the flagpole outside the house before the collision occurred, and ultimately ending O'Keefe's life. Now, he emphasizes forensic evidence, including the battery temperature on O'Keefe's phone and the health data corroborating the timeline. Brennan highlights Reed's 53 angry phone calls to O'Keefe's that night, leaving voicemails, but none to 911. Jen McCabe, hospitals, or others to help, indicating her awareness of the outcome. He described a debris field of taillight fragments in the yard consistent with Reed's striking O'Keefe and her SUV and driving away, leaving both O'Keefe and her taillight behind. Brennan asserts this physical evidence is unchangeable and supports the Commonwealth's case. Now, Brennan defends Carrie Roberts and Jennifer McCabe, arguing they were unfairly drawn into this case while showing kindness by helping Reed. He questioned why Reed was frantic and needed consoling if she believes O'Keefe was merely missing, asserting she knew he was dead and where he was. Brennan plays a video of Reed's interview admitting she knew O'Keefe's location, reinforcing her guilt. Brennan then argues that O'Keefe remained outside 34 Fairview all night, supported by the debris field from the SUV impact. He refutes defense claims that O'Keefe entered the house, noting that no witness questioned his whereabouts or suggested he went inside. Brennan emphasized there was no reason for O'Keefe to enter, and the physical evidence aligns with the collision occurring outside. Now, Brennan emphasizes that Reed's repeated statements at the scene, "I hit him, I hit him, I hit him," as a clear admission of guilt corroborated by multiple witnesses. He plays a video of Reed's interview where she questions saying that many times, suggesting she tried to backtrack, but the truth seeps up. Brennan portrays McCabe as trying to prevent Reed from incriminating herself, calling it ironic that the villain was protecting her, further highlighting Miss Reed's guilt. Brennan challenges defense witnesses Dr. Marie Russell and Dr. Elizabeth La Posada, who testified about dog bites on O'Keefe's arm. He argued Russell, a volunteer with no forensic experience in such cases, couldn't explain all abrasions and claimed no punctures, while La Posada saw punctures everywhere, creating contradictions. Brennan dismisses the testimony as lacking scientific rigor, undermining the defense's dog bite theory as simply speculative and unsupportive. Now, Brennan acknowledges the distasteful and dishonorable text messages from Michael Proctor, admitting they were hard to read and unfair. However, he argues they do not alter the scientific evidence, the DNA, hair, the debris field, and the phone data or the facts of the case. Brennan notes Proctor faced consequences for his actions, but no evidence was tampered with, planted, or distorted. He asserts that the Commonwealth's case stands without Proctor, as his testimony wasn't needed to prove guilt beyond a reasonable doubt. Brennan then refutes the defense's no collision claim, citing medical examiner Dr. Scorty Bellow's testimony, which he says does not rule out a car accident despite no lower body injuries, as she lacked full investigative details. He challenged the objectivity of the defense experts, Dr. Rentschler, noting his lunch with the defense team. Brennan emphasized the Commonwealth's unchallengeable timeline corroborated by forensic data, which is the phone battery, the health apps, physical evidence from the taillight fragments, O'Keefe's hair, DNA, and witness accounts. He asserts Reed got drunk, struck O'Keefe with her SUV, and left him there to die, stating, "There's no doubt what happened that night, and there's no doubt who did it." Brennan, he concludes by humanizing O'Keefe, rejecting Reed's dismissive interview comments, likening him to a body or a buffalo on a prairie. He emphasized O'Keefe's identity as a person murdered by Reed, reinforcing the Commonwealth's narrative of her intentional actions. And Brennan's final remarks that end closing arguments, urging jurors to recognize Reed's guilt based upon overwhelming evidence. Well, the judge then dismissed the jurors for a short lunch break, instructing them not to discuss the case. She informed them that only 12 of the 18 jurors will deliberate, with alternates to be selected later by the clerk, a process that she notes is the clerk's least favorable task. Counsel was then again called to a sidebar after the jury leaves, likely to discuss the final instructions or procedural matters, and that's where it stands. The jury is currently deliberating, and as of right now, it's almost 2 p.m. Mountain Time. So that'd be 4 p.m. there on the East Coast. They're probably going to deliberate for another hour, and then the jury will be sent home to think about it over the weekend, where more than likely they will talk to their family members and help come to a decision over the weekend. I say that jokingly, all right? But my experience is when the jury has all weekend to think about it, they usually come back over the weekend and usually make a pretty quick decision. But you never know. The jury can take as much time as they desire. There's no way of actually predicting it. My experience is jurors take their jobs very seriously. They're going to look at this. They're going to decide whether the government has proven their case beyond a reasonable doubt. And if they have not, then it is the jurors' solemn oath and obligation to find Miss Reed not guilty. If, on the other hand, that they believe that the government has proven their case beyond a reasonable doubt, it is their solemn oath and obligation to say guilty. They should not consider consequences, i.e. penalty. If there is a guilty verdict, they should not consider the people outside, because those people outside, protesters, commentators, are not the ones that heard the evidence that only the jurors did. And so those are the only people that decide. And I don't say other people could watch the trial. We all did, right? It's those people that have to sit and judge the credibility of those witnesses and the credibility of the evidence that has been presented and basically decide what happened. We'll bring it to you. We're on jury watch, verdict watch, I guess we should say. Either way, we'll have to wait and see. Next, a quick update on the Travis Dacker matter. So in a tragic case in Washington State, Whitney Dacker missed an opportunity to restrict her ex-husband, Travis Dacker, from seeing their 3 daughters. Peyton, who is 9, Evelyn, 8, and Olivia, 5, who he is now accused of murdering on June 6th of this year. Now, court records reveal that in September of 2024, a judge ordered Travis, a 32-year-old Afghanistan war veteran, to complete mental health and anger management counseling within 30 days as part of the custody parenting plan. Failure to comply would allow Whitney to limit his visitation rights. Now, Travis did not follow through, but Whitney failed to notify notify authorities or enforce her right to restrict contact, allowing unsupervised visits to continue. Now, the records show that during their 2022 divorce and initial custody proceedings, Whitney described Travis as having a loving and stable relationships with their daughters, raising no concerns about his parenting for 3 years. However, in September of 2024, Whitney detailed Travis's deteriorating mental health, citing complex PSD, borderline personality disorder, narcissism, and an unstable lifestyle that caused emotional distress to their daughters. She noted incidents of neglect, such as leaving the children unattended in an armory, taking them to Montana without notice, and living in a transient conditions, including an RV and a tent. Consequently, the courts temporarily revoked Travis's overnight visitation rights, but Whitney did not pursue further restrictions when he failed to comply with those counseling orders. Then on May 30th of 2025, Travis picked up the girls for a camping trip, and on June 6th, their bodies were found at a campsite in Leavenworth, Washington, approximately 38 miles from their home, with their wrists zip-tied and plastic bags over their heads, indicating obviously that they were suffocated. Travis, who has been on the run since, is wanted for their murders, and police warned that he has some military training and should be considered armed and dangerous. Now, Whitney's recent court filings and statements through her attorneys reveal she still empathizes with Travis, believing his actions stem from untreated mental health issues exacerbated by a lack of veteran support services. Despite rejecting his attempts to reconcile their marriage days before the tragedy, Whitney maintains Travis was a loving father whose mental health declined after military service. A GoFundMe has been set up for Whitney as she grieves and the law enforcement continues to search for Travis near the Washington and Canadian border. Tragedy all around. But I'm going to go on a limb here, ladies and gentlemen. If you kill your 3 kids, I'm sorry, you're not a good parent. Okay? You're not. Anything that you may have done up to those previous points, all completely erased, taken away when you kill your 3 daughters. Okay? So I get it. She feels bad for him. Mental health issues. I get it. But I'm just telling you, as a member of the public here, all right, you kill your 3 daughters, you're not a good dad. Okay? I don't care if you were a loving dad beforehand. Don't care. Gone. Erased. Doesn't matter. Killing your 3 kids makes you a bad person. Makes you a bad father. I challenge anyone to tell me otherwise. Next, Sean Diddy Combs. Things are getting freaky. And guess who showed up? That's right. So obviously, Sean Combs, the prominent music mogul, was charged with sex trafficking, racketeering, conspiracy, and as well as drug trafficking. That's why he's in federal court. Now, prosecutors allege that Combs used threats, drugs, and violence to coerce women into unwanted sexual experiences, employing his employees and associates to facilitate these acts. Now, the charges stem from events that have been described as freak-offs or king nights, which involve elaborate sexual activities allegedly orchestrated by Combs himself. The trial began approximately 5 weeks ago in Manhattan federal court, and it has featured testimony from former associates, ex-partners, and law enforcement, as well as physical and digital evidence, such as text messages, voice notes, and seized items from Combs' property. Back in March of 2024, Homeland Security raided Combs' Los Angeles mansion as part of this probe, and agents seized 17 retail-sized boxes of Astroglide lubricant, approximately 900 bottles of it, 200 bottles of baby oil, 5 firearms, including a shotgun, rifles, and one with a scratched-off serial number, a drum magazine, and 59 rounds of green-tip ammunition designed to penetrate body armor. These items were later presented in evidence, obviously, at his trial. Now, there was testimony of an incident in Las Vegas back in 2024, a hotel room involving the witness named Jane, a famous rapper, his girlfriend, and a male escort named Anton was referenced in court. The events became a point of contentious testimony due to the anonymity order preventing the use of certain names, which Combs' defense argued hindered their ability to gather exculpatory information. Then on Tuesday, the prosecution motion to dismiss juror number 6 came up. Now, before the jury entered, prosecutors requested the dismissal of juror 6, a 41-year-old black male from the Bronx who works for the New York City Department of Corrections, citing inconsistent statements about his residency. The motion was sealed and no specific details were disclosed in open court. Combs' defense objected, accusing prosecutors of targeting a black juror. The issue remained unresolved pending further review by the judge. And then we heard testimony of Jane, who is a pseudonym for Jane, an ex-girlfriend of Combs, testified about freak-offs involving extravagant sexual role-playing where participants adopted nicknames inspired by NBA stars. For example, Combs as Michael Jordan, Jane as Kobe Bryant, and a male escort as Shaquille O'Neal. She suggested these scenarios allowed Combs to explore his bisexuality fantasies indirectly, as he was allegedly too ashamed to engage with men openly. Now, a voice note from Combs to James was played where he called her his crack pipe, implying an addictive relationship. Now, Jane's response and other voice notes described their time together in Turks and Caicos as incredible and referenced the crack pipe metaphor, indicating mutual intensity in their interactions. Now, the judge had previously warned Combs against nodding vigorously at jurors, threatening to remove him from the courtroom. This issue resurfaced later in the week. Then we had the juror 6 dispute where Combs' lawyers vigorously opposed the prosecution request to dismiss the number 6, labeling it as thinly veiled effort to dismiss the sole black juror. Prosecutors countered that the juror's lack of candor raised serious issues. The judge deferred that issue, but jumping back to Jane's cross-examination, focused on her interactions with Combs and others during the freak-off. She described this incident in Las Vegas, where she traveled with a famous rapper and his girlfriend on a private plane, witnessed Anton, the male escort, engaged in sexual activity with the rapper and his girlfriend, watched and flirted with the rapper herself. The defense highlighted Combs' close relationship with the unnamed rapper, described as a top music industry figure, to contextualize the events. And Combs' lawyers argued to modify the anonymity order to allow the use of names related to the 2024 Las Vegas incident, claiming it would enable the public to provide relevant information. Needless to say, the prosecutors opposed that, arguing it was a pretext to harass and intimidate Jane, and the judge upheld the anonymity order, deeming the issue collateral to the sex trafficking charges. Now, Jane further provided details about the Las Vegas event, including her interaction with the rapper and the relationship. She admitted to flashing her breasts at the party and claimed that the rapper expressed a long-standing crush on her. Now, reports emerged that Combs was actively participating in his defense, passing dozens of notes to his lawyers daily, suggesting evidence and grilling them during the breaks. This earned him the nickname quarterback of his legal team, reflecting his shift from initial nervousness to strategic engagement. Now, Combs adopted a nerd defense appearance, wearing glasses and neutral tone clothing, while white hair and goatee due to lack of access to hair dye. This strategy, coined by his former attorney, Harvey Slovic, back in 1999, aims to subliminally present Combs as less likely to engage in criminal activity. I don't know where the glasses things comes from, but I always have clients like, I'm going to wear glasses at trial. Oh, do you wear glasses? No, but they apparently make you look more studious, like you wouldn't do something wrong. It's a thing, ladies and gentlemen. I don't know. I think it's hogwash. Anyway, prosecutors reiterated their request to dismiss the juror again, citing these multiple things that cannot be true as it relates to his residency. The defense offered to waive any appeal based on the juror's credibility, which Combs confirmed in court by saying, "Waived, Your Honor," but the judge planned to rule by the end of the day. Now, guess who showed up? Kanye West, or Ye, right? Isn't that what he's known as? He made a surprise appearance at the courthouse wearing all white outfit and sunglasses. He was warmly greeted by Combs' son, Christian King Combs, and defense attorney Xavier Donaldson. West nodded yes when asked if he was there to support Combs, prompting cheers from onlookers, and he briefly entered an overflow room with 3 security guards and left within an hour. There was also testimony from a Homeland Security agent who detailed the March 24th raid on Combs' Los Angeles mansion. He described finding 900 bottles of the lubricants, as well as all the magazines and firearms at the house. Well, we'll continue to bring you updates on the Sean Combs trial. I think we're about 3 weeks out, so we'll have to wait and see. Obviously, the defense position is, hey, this was all consensual, and what's the big deal? Certainly, there was no criminal intent to what took place. Just because you don't like it doesn't mean that it was illegal. We'll see how that defense works for them. Clearly, he's being portrayed as a not nice guy, abuser of women. Clearly, got some sexual issues that he's got to work on, whatever. But at the end of the day, the question is it illegal? Next on the docket, how's this for consciousness of guilt? A Florida man is accused of attacking another individual with a machete, and after causing injury, personally drove the victim to the hospital for treatment. Angel Ramos Acre, a 35-year-old resident of Kissimmee, Florida, was apprehended on Monday at the Osceola County Court, and according to court records, indicated he faces charges of aggravated battery with a deadly weapon and aggravated battery causing bodily harm. He was subsequently detained at the jail. The incident took place at a Circle K near the Irlo Bronson Memorial Highway. Now, according to the arrest affidavit, a store employee reported that Ramos Acre entered the premises and began shouting at her, prompting her to contact her brother for assistance. The employee's brother arrived and confronted Mr. Ramos, followed by the employee's boyfriend, who attempted to intervene. In response, Ramos allegedly struck the boyfriend in the face, and the affidavit states that Ramos then retrieved a machete from his truck to intimidate the brother and boyfriend, who were described as significantly larger in stature, causing them to flee. Ramos pursued them and, upon catching up, allegedly slashed the brother's arm. According to the affidavit, Ramos claimed the slashing was unintentional and expressed remorse, offering to drive the victim to the hospital as he felt bad about the incident. Needless to say, the sheriff office were called, and Ramos's truck was identified by the female employee and traced it to the Advent Health there in Kissimmee, Florida. Upon arrival, they discovered the victim's blood and the machete inside the vehicle, leading to Mr. Ramos's arrest. Now, ladies and gentlemen, I think I've told you this, and you saw my battle box. We get lots of sharp things, but I do have a couple of machetes, all right? Quick story about machetes. You don't play with machetes. Once represented a guy who nearly chopped off a guy's arm with a machete. You know what they were? They worked as landscapers. And they'd had a dispute over something. I don't even recall what it was. It was so many years ago. But apparently my client grabbed a machete out of his car, and the other guy had his arm up on his truck window with the window rolled down. And my client came up and whacked him in the arm, nearly cutting his arm off. I'd love to tell you how it ended, but my client returned to, I believe it was Jamaica or the Dominican Republic or something like that, before his matter could get resolved, and I never heard from him again. But don't play with machetes, man. Those things are sharp. They are meant to, whack down large weeds and trees. Don't do that. Machetes, bad. Next on the docket, this day in legal history. On June 13th, 1866, the 14th Amendment was passed by Congress, guaranteeing equal protection and due process under the law to all citizens applicable to the states. On June 13th, 1966, the United States Supreme Court ruled in Miranda v. Arizona, establishing requirements for Miranda warnings due to custodial interrogations. We've talked about this before. The court made this up. The court says we're going to, help out anybody that's being accused of a crime. If you're in custody and you're being questioned about that particular incident, you have to be advised your Miranda rights. And they said, we're going to warn you. Hint, hint, wink, wink, nudge, nudge, say no more, say no more. And yet people still refuse to listen to that advice and answer questions and waive their Miranda rights, ladies and gentlemen. If they read you your Miranda rights, you're a suspect. Lawyer, lawyer, lawyer. Say it 3 times unequivocally. They got to stop. Actually, they're supposed to stop at 1 time, but 3 makes the record clear. Next, on June 3rd, 1967, President Johnson nominated Thurgood Marshall as the first Black Supreme Court justice. On June 13th, 1977, James Earl Ray, assassin of Martin Luther King Jr., was recaptured in Cleveland after he escaped prison. Our legal quote of the day has to do with juries. The jury, which is the most energetic means of making the people rule, is also the most effective means of teaching them how to rule. This quote goes back to 1835 in a book titled Democracy in America, and it underscores the dual role of jury duty as both a civic responsibility and as the educational process, fostering an informed and engaged citizenry. It reflects the importance of jury service in upholding justice and the democratic principles. I know a lot of people want to get out of jury service. Go do it. I've never spoken with anybody who's ever said, oh my God, I hated that. That was the worst experience ever. They all think it's great and they want to do it again. I myself done hundreds of jury trials, never even made it into the courtroom when I've been called for jury duty. And finally, our dumb criminal or dumb criminals of the day, as it may be, we're going to call this the Great Doral Mail Heist 200-pound postal blunder. In the sun-soaked streets of Doral, Florida, a quartet of sticky-fingered bandits pulled off a caper that would make even the most seasoned mail carrier blush. Armed with a pilfered key and an audacious disregard for the sanctity of the United States Postal Service, these ne'er-do-wells made off with a whopping 200 pounds of mail from an unsuspecting apartment complex. Letters, bills, credit cards, and who knows what else were snatched in the heist and got the South Florida buzzing like a beehive poked with a stick. Now, the Doral Police Department, led by the ever-quotable Chief Edwin Lopez, wasted no time cracking the case. Thank God we have amazing detectives and some dumb criminals, Lopez quipped. No doubt, with a twinkle in his eye. Surveillance footage revealed the culprit's not-so-masterful plan, which culminated into a shopping spree at the Dadeland Mall. Their haul? PlayStations, an iPad, and because hydration is key, a single bottle of water, all charged to stolen credit cards. Truly, these are the masterminds of our time. 3 of the 4 suspects are now cooling their heels in custody. Ivy Marcus Allen, Guston Malher, and Latron Stedman. The 4th, Antoine Ronald McLean, remains on the lam, presumably plotting his next move in a hideout furnished with stolen postcards. We're not going to stop till we bring them to justice, Sheriff Lopez vowed, channeling the grit of a Wild West sheriff. These are people's livelihoods. These are people's safety. There you go, ladies and gentlemen. Our dumb criminal of the day. Criminals, quattro, 4 dumb criminals of the day. All right, that's all we have for today, ladies and gentlemen. Hope you enjoyed the show. Have a wonderful weekend. We'll see you next week. And obviously, we'll be bringing you verdict in the Karen Reed case. So make sure you keep the feed up so when it happens, you know. Thanks for watching. We'll see you next time. And remember, the Constitution matters.